This is Bloomberg Law with June Grasso from Bloomberg Radio.
Special Counsel Jack Smith is urging the 11th Circuit Court of Appeals to reinstate the classified documents case against former President Donald Trump, saying a judge made a serious error in dismissing the case. Smith said that federal judge Aileen Cannon's decision that he was unlawfully appointed by Attorney General Merrick Garland runs counter to precedent, rulings by judges across the country, history, as well as widespread and long-standing appointment practices in the Department of Justice and across the government. Joining me is Dave Aronberg, Palm Beach County State Attorney. To put this all into context, Dave, tell us about Judge Cannon's decision dismissing the case.
Judge Cannon made such a bizarre decision that it went against all precedent, and I think will almost certainly be overruled by the 11th Circuit. Cannon's best chance to keep this on the books would be if the Supreme Court decides to weigh in and then does something radical like they did in the immunity case. Clarence Thomas has already issued a concurring opinion that provided a roadmap for Judge Cannon to rule the way she did, but no other justice signed on to his concurring opinion, so I suspect the Supreme Court would not even go along with her approach. I mean, I'm old enough to remember a guy named Robert Mueller and Robert Hur and David Weiss. These are all special counsels in recent years, and there was no issue whether they could remain because of the constitutionality of their appointment. Judge Cannon applied a different set of rules to Jack Smith, and she'll be overruled for it. Then the big question is, will the 11th Circuit remove her from the case? I know Jack Smith would want that. He did not ask for it specifically, but the 11th Circuit has the power to do it on its own. Don't know if they're going to do it yet, but maybe that day will come.
So, Dave, explain what her reasoning was, why he was wrongfully appointed.
There's the appointments clause in the Constitution that allows for certain appointments, and they have to be confirmed by the Senate, and then there are inferior officers, so-called inferior officers. That would be the special counsel. But what the lawyers on Donald Trump's side, these are outside lawyers, by the way, and it was bizarre, again, that Judge Cannon even allowed these outside lawyers to participate in the oral arguments. I mean, this became a real political hot potato. This was not a Trump lawyer, but these were outside lawyers that first raised this argument. And they said that under the appointments clause, that Jack Smith needed to be confirmed by the U.S. Senate. He is not an inferior officer because he has total independence. So just like the Attorney General, he needs to be confirmed. He wasn't confirmed. Therefore, his appointment is unconstitutional, and Judge Cannon agreed. Now, the problem with that argument is that Jack Smith is not totally independent. He has a boss, the Attorney General. He has to get approvals and permissions from him. And so he's not totally independent. And you know who also has argued that Jack Smith is not independent? Donald Trump. Donald Trump has repeatedly bashed Jack Smith for being a tool of Joe Biden and Merrick Garland doing their political business. So it's kind of ironic that the argument that Donald Trump is proposing is opposite from the argument that the lawyers are proposing, and it's that argument in court that won the day with Judge Cannon, but I don't think it's going to win the day anywhere else.
Jack Smith's brief covers the landscape of legal arguments. So he starts with Cannon ignoring decades of precedent, including binding Supreme Court precedent. So tell us about the precedent.
The precedent is that special counsels are legit, they're legal under the law, they're an inferior officer, and an attorney general can appoint them, whether it was Archibald Cox or Robert Mueller. And, over the years there have been different statutes in place, and the statutes may have not been reenacted or, repealed, but special counsels remain. And there's never been any court that has looked at this issue, because courts have. They have. There's never been a court that has said, yeah, it's an unconstitutional appointment. You have to be confirmed by the Senate. It's never happened. It didn't happen with Clinton and Kenneth Starr. It didn't happen with Nixon and Archibald Cox. In fact, in the Nixon case, the Supreme Court did weigh in on this. And in dicta, meaning in just extra language in the opinion, they did say that the special counsel was legit. The way that he was appointed was okay. And so this goes against precedent for years, including Supreme Court precedent. And so that's why I'm very confident that Judge Cannon is going to be overturned.
She drew a distinction between the appointments of independent counsels. It's the predecessor to what's now called a special counsel, and Garland's appointment of Smith as a special counsel. And in that 1974 Supreme Court decision, the court was talking about a special prosecutor.
walks like a duck and talks like a duck, right?
I'm confused about the difference between them. I know that Smith said, there's no real difference, but is there a difference?
It's a distinction without a difference. Whether you call them independent counsel, special counsel, they serve under the Attorney General. They have to issue a report. They have to get approvals and permissions. They are not completely independent the way that they serve. At least the special counsel is not. And as a result, they don't have to be confirmed by the Senate. This has been litigated in other cases. I mean, Judge Chutkan reviewed this in D.C. There are lots of special counsels out there, and we've never seen this before. I mean, we just had a special counsel investigate Hunter Biden. It's continuing to investigate Hunter Biden. And so I guess Hunter Biden's conviction should be overturned because the special counsel, David Weiss, who prosecuted him, was improperly appointed, unconstitutional. You know, if you do it one way, you got to do it the other way. So she is opening up a can of worms, and that's why the 11th Circuit is going to come in and say, no, stay in your lane, you're being reversed. And it's possible because the 11th Circuit reversed her multiple times previously on the special master issue in this case that maybe they'll say enough. We're removing you from the case altogether. That would be Jack Smith's dream. Don't know if it happens yet, but that could happen one day if she keeps ruling this way.
So you're very confident, even though the 11th Circuit is very conservative, suppose Smith draws a very conservative panel.
Well, Smith drew a very conservative panel the last time he went to the 11th Circuit to ask them to reverse Judge Cannon on the special master issue. 3 judges. One judge, the head judge, Judge Pryor, very conservative, was considered for the Supreme Court under Bush. Then you had the other 2 judges who were appointed by Donald Trump. So it doesn't get more conservative than that. 3 judges, 2 of them appointed by Donald Trump. All 3 said, you're wrong, Cannon, and chastised her and repudiated her. So no matter how conservative this panel will be, I think it'll be the same result as last time.
What I think is one of the best lines from Smith's brief is, quote, from before the creation of the Department of Justice until the modern day, attorneys general have repeatedly appointed special and independent counsels to handle federal investigations, including the prosecution of Jefferson Davis, alleged corruption in federal agencies, including the Department of Justice itself, Watergate, and beyond. His argument covers, as I said before, the legal landscape. He also says, and tell me if you think this is going too far, that if this is allowed to stand, it could jeopardize the operation of the Justice Department and call into question hundreds of appointments throughout the executive branch. Is that going too far?
No, it's true. If you're going to throw sand in the gears here, then everything's at risk when it comes to the Appointments Clause. There'll be a new interpretation of the Appointments Clause. It just won't affect special counsels. It'll affect any other inferior officer where there is at least an accusation of extra independence. It puts every inferior officer at risk of being tossed aside unless they were confirmed by the Senate. And so, yeah, there are real ramifications for this radical ruling by Judge Cannon. And that's why I think for sure she's going to be overturned. Now, unless the Supreme Court steps in after the 11th Circuit and says, no, we're going to now create a new standard. And they could. I mean, I didn't think they were going to rule the way they did in the immunity case, so maybe they're going to do the same thing here. But I still think this decision by Judge Cannon is doomed.
So Trump's reply is due in about 30 days. How long will it take, do you think, for the 11th Circuit to decide the case?
It's hard to say. You never know with these appellate courts. Depends on their workload. And now because the election is in November and this case is not going to be tried before the election, there's no real sense of urgency to get it done right away. I think it may take a while, but I'm not as uncertain about the decision. I think the decision will be unanimous and it will be scathing. And Judge Cannon needs to worry that she'll be removed from this case and be humiliated based on her decisions that have been out of step with the law multiple times.
Speaking of not rushing things, Smith filed his legal argument one day before the deadline set by the appellate court. I mean, usually you think of special counsel offices as being, more efficient than that and getting it, not waiting until the last minute.
Oh, on this one, I have to disagree with you, June. I think by filing a day in advance, that was efficient. Most parties will just file it on the last day. They've got so much going on. He did it early. He did it the day before he had to. No, I give him plaudits for it. I give him kudos for doing it. For federal prosecutors in a high-profile case where so much is riding on this, he could have waited another 24 hours. He did not. No, I think that's fine. I think it's impressive.
Let's turn to D.C., the D.C. election interference case for a minute, because according to Bloomberg sources, Smith has decided against having a hearing to present evidence in the case before voters go to the polls, sort of a mini trial. I wonder what you think about that.
You know, I'm a bit surprised. I thought that it could benefit the public to see the extent of Trump's involvement before, during, and after January 6th in a mini trial. But I think it's just that Jack Smith has other considerations. First, I think they're really taking the time to really understand the Supreme Court's ruling. They're going line by line, I'm sure, through the indictment and going up and down the ladder, talking to the Solicitor General to determine what they can pursue and what they can't. They want to avoid some gray area, and that takes time. But also, I think having a mini trial could jeopardize the case in some ways. Number one, it could tip off Donald Trump and his team as to what the evidence is going to be, what the witnesses are going to say. Number two, it could jeopardize Trump's Sixth Amendment right to a fair trial and thus jeopardize any conviction on appeal if a judge rules that by doing a mini trial, putting on all this evidence, it unfairly taints the jury pool. And Jack Smith wants to avoid that. And then third, Jack Smith is very careful about protecting his witnesses. And to put Mike Pence on the stand right before the election, would put him at risk. And I think that's part of it. I think he'd worry about him and other defendants being threatened, intimidated, and harassed. And so he may just say that, we're just going to try this after the election. Now, one other thing on this, June, there are some people who think that it's because Jack Smith and Merrick Garland don't want to look political by doing a mini trial this close to the election. I think it's a bad reason not to do this mini trial. No matter what you do, you're going to look political. No matter what you do, you're going to be called out for being political, no matter what decision you make. You got to just follow the evidence and the law and tune out the noise.
Okay, coming up, we're going to talk about the special counsel filing a new indictment against Trump in that January 6th case. You're listening to Bloomberg. Special Counsel Jack Smith has filed a new indictment against Donald Trump over his efforts to undo the 2020 presidential election. It keeps the same criminal charges but narrows the allegations against him following a Supreme Court opinion that conferred broad immunity on former presidents. The new indictment removes a section that dealt with Trump's interactions with the Justice Department, an area of conduct for which the Supreme Court, in a 6-3 opinion, said Trump was entitled to immunity from prosecution. And the updated criminal case no longer lists as a co-conspirator Jeffrey Clark, a Justice Department official who championed Trump's false claims of election fraud. The indictment retained the allegations that Trump attempted to pressure then Vice President Mike Pence to refuse to certify the electoral vote count. I've been talking to Palm Beach County State Attorney Dave Aronberg. And as far as the election interference case, explain why the special counsel had to file a superseding indictment.
Because based on the Supreme Court's immunity ruling, you can't charge him for things that are within his core official duties as president. And one of those things is appointing an attorney general, having communications with the attorney general and his team. And Trump, amongst the allegations against him, is that he improperly tried to pressure the attorney general, the acting attorney general, and tried to get him removed until he would overturn the election, and was working with Jeff Clark, another member of the DOJ, to try to have a coup within the Department of Justice. The Supreme Court said, now, all that's within the president's core powers, he's immune. And so they've got to drop everything related to that. And then the ruling is so broad that you can't even use official acts as evidence for criminal conduct, even when that criminal conduct is unofficial. So you can't, call a witness from within Trump's executive branch to testify on something. These are things that they are going to have to meticulously go through to make sure they're not running afoul of this very broad and very confusing Supreme Court opinion.
But the conspiracy to obstruct an official proceeding, that remains.
That will remain, even though there was a different Supreme Court decision that limited the use of that statute, obstruction of an official proceeding. But I think you can still charge that. You just can't use as evidence some of the communications that may provide proof that he did obstruct an official proceeding. You have to try to get a conviction with one hand tied behind your back, thanks to the Supreme Court.
Smith's team and Trump's team are scheduled to file briefings August 30th on how they want to proceed ahead of a September 5th hearing before the judge. So perhaps we'll learn even more then. Thanks so much, Dave. That's Dave Aronberg, Palm Beach County State Attorney. Sharp turn now to intellectual property law and guitars. doesn't love a guitar battle to determine which player is the most skilled? But recently, the guitar battle that's been getting the most headlines is the one in court between two guitar companies over trademark rights. Gibson Guitars argues that Dean Guitar's use of the V and Z shapes ripped off its trademarks. And Gibson won the first round when a jury decided in 2022 that Dean sold counterfeit guitars. But Dean won the second round when a federal appeals court recently reversed the decision, saying the trial court had wrongly excluded evidence and ordered a new trial. So are they back to square one? Joining me is intellectual property attorney Ronald Bienstock of Scarinci Hollenbeck. He represented Armadillo, the maker of Dean Guitars, at the federal appellate court. Can you start by talking about what Gibson was accusing Dean of?
There's a lot of guitar history here, and we're going back to the 70s. So set the Wayback Machine, and maybe it's just Back to the Future Part 4, 5. We're talking about electric guitars here, and much more so on the rock side of things, not really jazz guitars. You know, there are a lot of different types of electric guitars, and everybody has a sort of thing about growing up with my first guitar was this, and so I've stayed with that body style. Some people are devotees and buy 10, 15 of a certain style. So we're going back to the 70s when upstart companies started to make these guitars that weren't being made by the older builders, if you will, the Gibsons, the Fenders, things of this nature, and started to compete with them. And one of those competitors was a company called Dean Guitars. Started in the Midwest in 1976, 1977, starts to bring out instruments in particular shapes. Two of the shapes at issue here are shapes you've seen before. One is called a V, literal V. Gibson refers to it as a flying V. And an Explorer shape, or called by Dean at the time, the Z shape. And to just make matters more complicated, stay with me on this, these were guitars originally introduced by Gibson in 1958 and 1959 as an attempt to say that Gibson could be competitive with the upstart in those days, Fender. Fender Guitars was building solid body guitars. Gibson did not build a lot of solid body guitars. And they brought these unusual guitars out, solid body guitars, showed them at a major trade show, and they were miserable failures. They made 100 of one of them, the V, and 22 of the Explorer, and they were gone. And you didn't see another one of these V guitars until 1967, when Jimi Hendrix started playing a V that was hand-painted by a friend of his. And you didn't see the Explorer shape come back until Dean and another company called Hamer started building these, saying, hey, I can bring these back. I can reintroduce these. And they did, and brought them back in around 77 with features and parts that people were looking for.
And what was the guitar market like?
So guitars can be very analogous to cars. I am not a car guy necessarily. I am a guitar guy. But there's hot-rodded versions of these guitars, literally, where pickups, the thing that picks up the sound from the strings, is a very specific build. And certainly it's electronic, so there's a certain sound to it. And you go, I like that sound. I can't get that from my other more standard Gibsons or Fenders. That's how competition occurs in the guitar marketplace. Musicians say, I really want that sound, or I'd like that guitar that I enjoy playing that looks like this, but it doesn't have the features I want. So can you put those features into that shape? Sure I can, says builder. I can do that, and I'll put them into the marketplace. And maybe it's a fancier wood top, a veneer of a very attractive wood, or a certain paint job or finish, very much like fancy cars. Right? Everybody wants to have their car hot-rodded up a little bit, and that's how you get here. So that's the background of where Dean started. Dean makes these guitars for a solid 10-plus years. And like most companies, upstart companies, they go through some trials and tribulations. There's a couple of versions of that company. And eventually in the 90s, it is sold. And eventually Armadillo, distributor, buys the brand Dean, puts the brand on a higher level in the marketplace and brings it out and starts selling Dean model guitars, and continuously does that. So you've effectively got these guitars, these shapes, for 40 plus years.
So that brings us up to Gibson suing Dean. Tell us what happened there.
In 2019, Gibson sued Armadillo/Dean saying, hey, you're infringing and making counterfeit product. And of course, Armadillo Dean's response in the trial, which we did not handle, was logically, we've been making these for a long time. Latches should apply. What have you guys been doing for the last 40-something years? And more importantly, how could it be a counterfeit? We put our name on it, and it's got a very specific, unique headstock. That's our trademark. We have a trademark on that.
Doesn't Gibson have a trademark on the shape?
Gibson doesn't apply for a trademark until the latter part of the 90s for these two guitar body shapes. And they're two-dimensional outlines of the V, just the body of the V, and the two-dimensional outline of the body of the Z or Explorer. They do get those two trademarks. Yes, they do.
So Gibson is accusing Armadillo Dean of violating those trademarks. Was Dean's main defense that the shapes were generic?
So the defense position is that these body shapes have been made by countless third parties, and we can prove it. We have evidence to prove that. And we're going to show that at trial, that everybody, not just us, we're not alone here, that everybody in the guitar marketplace for some period of time, and remember, Gibson stopped making these guitars for a long time, one well over 5 to 6 years, and the other one is more like 16 to 17 years. Gibson, they weren't focused on these guitars per se. They may have made some of their own, but everybody else was making them, and everybody else was advertising them and saying, here, this is my version of this guitar style. Look what I have different things on mine. You should try mine. And then you also had them advertising using, and it's very big in the instrument business, endorsers, very much like sports equipment. Look at us. We've got this famous guitar player. And musicians are heavily influenced by who plays what. You know, when you've got a famous guitar player playing a certain style of guitar, people gravitate and they go, I want one of those. In the instrument side of things, we call it GAS, Guitar Acquisition Syndrome. Got to have that. I got to have that. And people seldom have one guitar. People have lots of guitars. Armadillo Dean's position is that lots of people made these. Therefore, we're going to prove that these marks are actually generic. Sure, you may have gotten a registration, and at the time, people didn't oppose, and that happens. But just like the Fender case, the Stuart Spector versus Fender Music Instrument Corporation case, we're going to show decades of usage by other companies makes this generic. And have a trademark in something that's generic. On the eve of trial, the court held something different. The court allowed a motion in limine, which was a wholesale exclusion of evidence of all of these prior years of usage by third parties because they're being accused of copying them, but you can't have a trademark in something that's generic. On the eve of trial, the court allowed a motion in limine, which was a wholesale exclusion of evidence of all of these prior years, and that affected the trial, and hence I think is how you get the somewhat unusual decision, the verdict from that trial. $4,000 worth of damages, latches applies, but you're a counterfeiter?
How far back did the judge allow evidence of similar shapes?
Only 92.
So that's still a long time.
Well, remember when the guitars got brought out? They were brought out in the 50s. They stopped making them, and other people made them 60s, 70s, 80s, 90s. So you've got 4 decades of evidence of third parties. And all these third parties go to the largest guitar market in the United States. Not all of them are made in the U.S., but they're imported here. So you've got decades of other third parties bringing guitars like this into the United States and selling them here, advertising and selling them here.
Now, the Fifth Circuit reversed. Tell us about the Fifth Circuit's decision.
We were brought in to handle the appeal. So the Fifth Circuit fully reversed and remanded and said that it was error, that it was abuse of discretion by the lower court to have had this wholesale exclusion of evidence, and said that the defendant was deprived of fully being able to present the evidence they felt that they could in terms of proving the genericism of the marks. So it's been reversed and remanded, and there'll be a new trial.
Gibson had asked for an en banc hearing of the full Fifth Circuit. What happened to that?
The initial appeal was a 3-0 decision, and they requested en banc, and that was rejected outright.
It's hard for you to judge this as the attorney who won at the Fifth Circuit, but you're going back to trial, basically starting again. How big a victory was this?
I think there's two crucial issues here. One is, everybody loves to claim a victory lap. This is truly a victory lap that can't be claimed because that decision in the lower court did prevent the defense from being able to present this evidence. And there's other issues here that probably won't make its way through the process because they're somewhat extraterritorial. But there's precedent for this type of case in other jurisdictions. In Japan, there was a high court decision in Japan in 2000 that said that all Gibson trademarks were generic because everybody had used them, if you will, copied them in Japan, unfettered for decades, and they didn't have any protectable interest now in this intellectual property in Japan. So you can make any type of product in Japan that may look like a Gibson model. And that's been going on now for 24 years. There's a case in Europe, in the EU, that one of these models, this Flying B model, that is also now to be judged generic. It was appealed, that lost. So you've got other jurisdictions that understand that certain guitar bodies, certain guitar shapes have become generic. Everybody's made them. Everybody's used them. And that's why I go back to that Fender case, because that's exactly the same theory. Fender tried to bring trademark applications for 3 of the most popular guitar shapes in the world, and they were unable to. I know that because I tried that case. The matter is very clear. The parallels are so stark that there are enough popular guitar shapes that people make their versions of them and have made them for decades. And the impact is that the usage of third party in other cases, I think this case sets the precedent.
Is the Gibson more popular than the Dean? I mean, what, as far as today's musicians?
Well, these are pretty specific. These are interesting guitars that the V literally you can't really play sitting down. So it's like a rock guitar kind of thing. It's definitely an image type of guitar. And then the Explorer is also a little more difficult to play sitting down. Also very sort of rock look. Remember, they were brought out in 58 and 59 during the Sputnik era, sort of space age for the time. Are they more popular? I don't think these were anybody's best sellers, but I think these particular 2 shapes were very much associated, particularly in the 70s and 80s with Dean, that people knew the Vs and, as they called them, Zs, were amongst 2 out of the 3 most popular Dean guitars because they had, like I said, specific shape, but different finishes and different features that were really popular. But are they the most popular? No, they're not the most popular for anybody.
Well, it will be fascinating to see if there's a different verdict the second time around. Thanks so much for joining us. That's Ronald Bienstock, a partner at Scarinci Hollenbeck. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.